Judge Dukes presides.
Good morning, y'all be seated. Thank you. I got all kind of water.
If they did not print it, I can have a clerk print it. If you can wait until your turn.
Oh, yeah. Did we end up printing the copies? Okay, great. So we've got enough for Rita, one for me, two, as many as y'all need, and then one to go back to the jury, right?
I was gonna say, we can use mine if you want.
Okay. All right. No, that's all right. We'll use Rita's and just don't draw on it, I guess. And
There's a Xerox machine right
oh, okay.
Okay, honey.
Nevertheless, we'll just, unless you want to keep it, you can have mine. It's all done.
There's just, yeah,
Is-
I'm gonna mark some.
Go ahead.
I've seen the jury charges, and I think I sent a response back. I just want to make sure they're for you to read, and they're not going to go back to the jury.
What do you mean, the response?
The charges,
The charges?
yes.
And we're still kind of off the record talking, but
Yes.
uh, then. Are you all set? Good morning, then. We're back on the record in the case of State versus Lewis. Yesterday, I got together with counsel and had a preliminary discussion with regard to the charges for the jury. There were several issues left unsettled and undecided, and Ms. Bright Matthews, I am happy to hear from you on those.
Judge, Mr. Murdoch will argue that motion.
You know, you just told me that. I'm sorry. Mr. Murdoch, I'm happy to hear from you, sir.
Your Honor, may I please court?
Please, go ahead.
Your Honor, as you stated yesterday, the defense as well as the state had a conversation as to a spoliation charge. If I may approach, I have some case law.
Thank you.
Your Honor, I'm going to reference back to the Stokes case. I believe it's the third page, Your Honor. In the second paragraph here is where the Supreme Court has held that jury charges which advises the jury, when evidence is lost or destroyed, a party may, by a party, an inference may be drawn by the jury that the evidence was lost or destroyed by that party would be adverse to that party. And it cites the Kershaw County Board of Education versus Gibson, I believe that's how that's pronounced. Your Honor, the spoliation charge we seek to submit to the jury comes straight from this case, Your Honor. And the state has, in response from yesterday, handed to us a case, State v. Cheeseboro. Your Honor, I believe the state handed you a copy as well. This case, referencing preservation of evidence, is specifically tailored towards establishing due process violation. Here, we're not arguing that there is any due process violation. We're simply seeking a jury charge to the jury as to spoliation of evidence due to the fact that there was no 911 call preserved in this case. There's been testimony in the case that officers arrived on scene, failed to provide any type of report that could have had any type of evidence, could have been beneficial or exculpatory for a defendant. Your Honor, also handed you another case, which is going to be the Pringle case. If you could reference to the last page of the Pringle case, the Supreme Court's also upheld jury charges when the evidence is lost or destroyed by a party, which is essentially quoting the Gibson case, that a party would have been able to have been which is lost or destroyed, a party would have been able to been adverse to that party. As an initial matter, a party seeking the inference must be prepared to make a showing that the document or evidence might reasonably have supported the presumption being requested by the fact finder. Here, the defense has argued that the only evidence that has allegedly incriminated our client was a 911 phone call from the hospital. There has been no showing of any other evidence that has led to or transpired this entire case other than the 911 phone call. And we believe that it's showing that the 911 call was never preserved would have reasonably supported our presumption that to the jury that that's the only evidence to establish any wrongdoing on behalf of our client. And for those reasons, Your Honor, we think a spoliation charge to the jury would be appropriate.
Let me make sure I'm clear on the motion. The evidence that you're referring to is the audio version of the 911 call. Is
Yes,
that
Your
correct?
Honor.
And you're not asserting any bad faith on behalf, on the part of the state, is that correct?
No, Your Honor. The case law specifically says that you do not need to establish any bad faith. Simply that it's been lost or destroyed. There's that or in there. Loss could have several different terms, Your Honor, and I believe as testimony provided that a 911 phone call would be preserved for 3 years. The state's failure to preserve the 911 phone call within the 3-year time period, with a case of circumstances as such we have here, would be able to draw, as referring back to the Pringle case, that we could make a showing that the evidence might have reasonably supported our presumption that there is no evidence other than a 911 phone call that the state has relied on in this entire case has transpired. And for that reason, we think the spoliation charge would be appropriate, Your Honor.
Thank you so much. I'm happy to hear from you.
Thank you, Your Honor. I think it's extremely disingenuous to assert that the 911 phone call is the only evidence against Mr. Lewis. However, let's talk about the 911 phone call. The 911 phone call was third-hand information from a staff member at the hospital. That is who called 911 to relay concerns that Leanne had relayed to a staff nurse, to the shift nurse. Leanne testified. She was cross-examined. So There is nothing in that 911 phone call that has not come out. It has come out in extreme detail through Leanne Kellum's testimony. Secondly, the state did hand the court and the defense State versus Cheeseboro, which is a Supreme Court case dealing with a criminal case. Neither one of these appellate court cases deal with a criminal case. And as established in Cheeseboro, there is a specific rule regarding spoliation. The burden is on the defense to demonstrate a due process violation. They're saying, oh, well, we're not asserting a due process violation, but that's the test for a spoliation charge, because they have to show that the state destroyed evidence in bad faith, or that that evidence possessed some sort of exculpatory value before it was destroyed. And there's no way the defendant can obtain evidence that's comparable. Well, the direct evidence from the information contained in that 911 phone call would be Leanne's testimony, because those are the concerns that are being relayed.
Keep going. You're not objecting, you're just standing, is that? Okay, all right, go ahead, please.
The information that is being relayed to the nurse and that the nurse relays to law enforcement is a concern that the husband may be involved, because Leanne brought that to the hospital's attention. Leanne has testified. She has put all those concerns on the record. She has been cross-examined about those concerns and the events of the night previous, where there was a violent domestic incident that she witnessed. Again, the defense has not shown any bad faith. There was absolutely no testimony that there was bad faith. We have more reliable evidence in the record than third-hand information that was received from 911. And I will say the information received from that call is contained in the CAD report that was turned over. The only thing that is missing, and it's just because it wasn't preserved, is the voice of the nurse saying, hey, we're calling law enforcement because the daughter of the victim has concerns that husband may have been involved. Thank you.
Thank you. Any
Your Honor,
quick
reply.
final thoughts? Go ahead.
The state's assertion that there's direct evidence from testimony from Mrs. Cronkey on the stand. Mrs. Cronkey never made the phone call. There is no direct evidence that she was the one who made the 911 phone call. And further, if you're inclined to accept the state position on establishing this violation, the second part is, or that the evidence possessed an exculpatory value apparent before the evidence was destroyed, or the defendant, and the defendant cannot obtain other evidence of comparable value. There's only one 911 phone call, Your Honor. There's no way that the defense can obtain any other evidence of any comparable means of the original 911 phone call. There is no other phone call. That was it. And as stated earlier, the phone call is the only evidence in this case that this entire case has transpired. There is no direct evidence that this case has transpired. And for those reasons, we believe that the spoliation charge to the jury is appropriate.
Thank you so much. Oh, go ahead, please.
Just briefly, the CAD report and the information in that CAD report is comparable evidence. Thank you.
Thank you. I am happy to hear your second motion. Was there not a second one? There is
No,
a
Your
second.
Honor, that was it.
That was it? Okay. All right, I had an opportunity to research this issue last night and read some case law about it, and I'm inclined to respectfully deny the motion to add the spoliation charge to the balance of the charges. With regard to the balance of the charges, I've been handed a copy of what I understand is what was, except for what was just stated, what has been agreed to. Have all counsel had an opportunity to review it?
Yes, I have. I think I sent a couple of changes. I haven't looked at it since then. It was just typographical.
Okay.
And I just had the clerk print that for me. I'll be able to replace it and show. It was just some typos that were.
All right, so
basically one word in one place and changing the spelling on another place. But that was only on the arson.
Did you send that to council, so we're all?
I sent it to reply all.
All right, well, I guess, I don't know if we need then to run, a whole tree worth of copies for everything, unless
Just
you,
maybe one sheet, 'cause it's
if you
just
can
all-
make the one sheet, I'll read from it, and then so the jury doesn't believe that we're all bad spellers, I'll use the one that I'm reading from that'll have the clarifications for the jury. Anything else then before, how long will that be?
She's getting it right now.
Okay, and you're going to take it apart and reassemble it?
Yes, sir.
Okay, fantastic.
And I'll just put it in this.
And the charge will go to the jury, the paper charge. Everyone is in agreement on that?
Yes, sir.
Okay. Anything else then before we bring in the jury?
Nothing from the state.
Did y'all work out where the easel was going to stand?
I'm not using it, and so I think once I'm finished, if Ms. Bright Matthews can have a moment to set up her situation.
As long as you need, yeah, so.
Thank you.
Oh, I forgot. Did y'all have an opportunity to look at the verdict form?
I did.
Yes, sir. No
Everyone in
objection.
I can send it.
agreement on the?
It should have really just 2 not guilties, but
Well, I can't print it that way, so, all right, but thank you. All right, this will be the official verdict form then. All right, sir, can you please bring the jury in? Good morning. I hope everyone had a good evening. Did everyone follow the instructions with regard to speaking with anyone about the case, doing any research, all of that? Okay, great. Did anyone try to contact any of you with regard to the case? All right then, let's go ahead and begin. Ladies and gentlemen, the parties have presented their evidence in the case. It is now time for the attorneys to make their closing arguments. The arguments of the attorneys are not evidence in this case. Their statements and arguments are meant to help you understand the evidence and apply the law to the evidence. You should disregard any remark, statement, or argument which is not supported by the evidence presented during the trial or the law that I will explain to you after the arguments. Does everyone understand that? All right then. I am happy to hear from you, ma'am.
Thank you, Your Honor. May it please the court. Terry Lewis was a survivor of domestic violence, but not for long. Craig made sure of that, and unfortunately, she's not here to tell her story. We hope that his actions and the truth that Leanne spoke to you resonates, and that it's enough for you to hold this man accountable for such a heinous murder. There is no dispute that Craig Lewis was at Wade Hampton when Terry Lewis was set on fire. He places himself with Terry at the crime scene. The only thing in question is whether this was some terrible accident or if it was an intentional criminal act. I don't want you to get bogged down by all of these peripheral issues that the defense has brought up, these probate court matters, Terry's health issues from 2012 and 2014. She had tremors. She had a balance issue years before. Craig says she lit herself on fire, lighting the same fireplace that she had been lighting for 25 years. None of those issues lend any insight to whether or not Craig set Terry on fire, or whether it was an accident. But you know what does? Craig and his actions, as well as the scene. Craig lends us a bunch of insight. The night before he claims Terry lit herself on fire using the same fireplace that she has forever, he gets into a violent domestic with her. Terry, hysterical, calls her daughter Leanne, 2 o'clock in the morning, to come get her. She's outside with what she could grab. They head on down the road. They have to turn around about half a mile because Terry realizes she doesn't have the keys to the Wade Hampton house. She goes back. She bangs on the door. Craig opens the door, slams it in her face, slams her hand in the door, throws things at her, pushes her down the wheelchair ramp in the back of the trailer. Eventually, he screams at Leanne to take her away before he hurts her. He screams that he has given her everything, but she is cheating on him, and now she gets nothing. Well, how does one ensure that one gets nothing? That sounds like a threat. That sounds like he wants her dead. Leanne takes Terry to the Wade Hampton residence, situates her there with her daughter's phone so she can get in touch if anything happens, if anything's going on. She checks on her the next morning. Everything seems fine. When she's at work, she starts getting hang-ups at about 10 a.m. Is that Terry calling for help? That makes sense. Craig's back. Leanne thinks nothing of it until after she's burned on 38% of her body, after she's at the hospital, and then she relays those concerns to the nurse. We don't know how long she was burning while Craig cleaned up. And when he realized she was not dying, he finally decided to take her to the hospital. But what he didn't do was call for any help. Let's talk for a minute about Leanne. She's an only child. She's an only daughter. She's extremely close with her mother. She's a devoted daughter. She was Terry's biggest advocate during her life and during her death. A daughter that would love nothing more than to get her mother back. She got on this stand and told you that Craig was not always bad. Things were not always bad between Craig and Terry. They had a long relationship, but things got bad at the end. The fact that Leanne does not think that her mother's murderer should benefit financially from the murder of his wife makes sense. It does not make her a dishonest person or a greedy person. In fact, it seems logical, and Leanne simply wants justice for her mother. She has waited 6 long years. This family has suffered. When the defense tried to cross her on her prior statements, it was, how many times did Craig slam her hand in the door? 5? Oh no, I think you said 3. No, was it 4? Okay, that just means she wasn't practicing her testimony. It's not inconsistent with the facts. She told nurses at the ER when she got to the hospital about the domestic because she was concerned that it may not be an accident and wanted police to look into it. So let's talk about when law enforcement was dispatched to make contact with Craig. What was he doing? He was in the carport, hosing down what appeared to be fire debris, cleaning up. When police told him he was being detained, he goes straight to his SUV, starts up the car, and tries to leave. He failed to respond to commands to get out of the vehicle. Several officers had to pull him out of the car. Craig Lewis, if you haven't noticed, is quite a large man. I believe David Long even said he looked like he had lost some weight. So he's far bigger than any of the officers that took the stand. So it did take several of them to pull him out of the car. It's also kind of an awkward thing to do. Regardless, he was eventually detained. But why was he trying to leave? And why did he not call 911? Why is he cleaning up? Why is there a couch missing from the living room that's burned up and thrown in the woods? Why was he clean as a whistle at the hospital? No soot, no burn debris on him, nothing. Terry's clothes aren't burned. Where are Terry's burned clothes? Probably in a smoking fire pit at the Kansas City residence. Why can Craig not answer any questions at the scene after Deputy Mullen gave him Miranda about what happened and how he tried to put the fire out? What do you mean? Because he didn't try and put the fire out. He didn't try to help her. He didn't call for help. The scene tells us a lot, so pay attention to those pictures. We have a wood-burning stove that Craig claims Terry was lighting and it blew back on her. Now, we don't even have any evidence that these doors were open. These doors, as testified to by the crime scene folks, had what appeared to be some of that fire debris residue on the outside, not on the inside. The doors were closed, okay? You can't light a fire with the doors closed. Also, if you look inside the fireplace and around the fireplace, there's cigarette butts, there are things that are flammable, paper over here, there's a chair over here. Nothing is singed around this fireplace. There is no damage to anything around this fireplace. Those cigarette butts are intact except for the part that was smoked. Those cotton ends are not singed. What is singed is a couch that's halfway across the room in the place that Terry would always sit. She always sat to the left, exactly where the couch is burned. That is then located in the woods off Risher Mountain Road. We also have bloody footprints traipsing about the house that come back to Terry from before Craig made her clean up, change clothes, what have you. He obviously wiped her feet off before taking her to the hospital, but DNA doesn't lie. It's Terry's blood. in the House of Horrors. The other expert testimony we heard about was regarding ignitable fluids. Maybe they were used, maybe they weren't. You heard that they could be present, they can be burned off during a fire, they can evaporate. However, everyone knows that a couch can go up in flames like this. You don't need an accelerant to light a couch on fire or light someone on fire on the couch. Light the couch on fire to light someone on fire. People fall asleep with burning cigarettes and burn their house down. But that's not what's alleged here, because the story that Craig tells is far different, and it has nothing to do with the couch. Terry's burns are not indicative of some sort of blowback from a fireplace accident. A burst of flames from a fireplace would not set her entire body on fire. Her entire front body is on fire. What makes sense? Craig's sooty jeans found in the house. They're in evidence. He didn't go to the hospital in these. He wasn't in a big hurry. He was going to clean up. What I found interesting was when the defense was accusing Sergeant Varnado of not calling the fire department when he arrived on scene at 3 in the afternoon. We've got Craig with his wife burning to death, not calling the fire department. That's who should have called the fire department when Terry was engulfed in flames. You all have common sense as jurors, and you get to use that in determining the truth. That is your job here. But for Terry being lit on fire, she would not have been bedridden for months. She would not have suffered for months and months and months before contracting pneumonia, to compromised lungs, compromised because she breathed in fire. The ER doctor, Dr. Fisher, told you about the soot and burns that he saw in her mouth. The pathologist, Dr. Beaver, concluded that her death was the result of complications from thermal burns. Injuries that she sustained on January 17th of 2019. I'm not asking you to make large leaps in judgment. I'm not asking you to use your imagination. I'm asking you to use your common sense. The circumstances and facts that surround Terry's death point conclusively to Craig being the perpetrator. Things got bad because he was convinced that Terry was cheating on him. Terry got away from Craig that night, but he made sure she wasn't going to get away from him again. He also made sure that she was not going to be able to refute his story, and he stuck around the ER long enough to make sure that she couldn't tell a different one. She was a woman who had been beaten the night before. Her abuser takes her to the hospital and stands watch while she's intubated and goes unconscious. He decided what to tell the hospital and what to tell Leanne. Recall that both the nurse and the ER doctor did not know whether Terry was actually verbal at that stage, and she was intubated within minutes. Dr. Fisher told you that when he reports patient stated X, Y, and Z, it's a whole summary of information that has been relayed in a high-stress situation. Their concentration was on treating their patient. Remember that this is a court of record. If there's something I say that doesn't make sense, that is not how you recall the testimony, or something the defense says that is not how you recall the testimony, you can listen to it again. You can request to hear it. Don't necessarily take our words for what was testified to if that's not what you remember. Judge Dukes will charge you on the law. He is the sole judge of the law. I will point out that he will tell you that the state can rely on circumstantial evidence so long as it points conclusively to the defendant. He will also instruct you that you must be convinced beyond a reasonable doubt. And what that means is that you should be firmly convinced of the defendant's guilt to find him guilty. The state need not overcome every single doubt because that would be impossible, and the doubt must be reasonable. So at this point, Ms. Bright Matthews will get a chance to give you her closing statement, and I will get a chance to briefly respond to any new argument that she brings up. But in the meantime, I really appreciate your attention and time. In this case, it's extremely important to all parties here, in particular, Leanne and her family. Thank you so much.
Ms. Bright Matthews, I understand you need a minute to arrange your
I
exhibits.
think I'll be okay with that.
All right, please proceed then.
Court. Good morning. Thank you for your service. I know a lot of times people don't understand how appreciative I am, the court is, the state, and the defendant is for you giving us your time. It is an important civil duty to serve on a jury. You've been here for 4 days, and on this rainy day, hopefully, this will be the last day you're here for the week. I want to express my thanks to the state, Ms. Swanson, for trying a good case. She can only try the case with the facts and the evidence that's given to her by the Sheriff's Department. She's done a good job trying to try this case. I want to thank the court for giving my client, Craig, his day in court, a fair trial. My team, my supporting team, I want to thank Brian Murdoch. This is his first, and he's sitting with me, and I think he's done a fine job. I want to thank Teresa McDonald from my office for helping out with trial, and most importantly, I want to thank my client, Craig Lewis, for putting his life in my hands, for trusting me to zealously advocate for him. And in that regard, I want to say this. If something I personally did that you didn't approve of, don't take it out on my client. Take it out on me. At the beginning of trial, I told you there were some things you would not hear and some evidence you would not see. I told you that there is a lot going on in this case that will require your independent life experiences, your knowledge of Walterboro, your knowledge of the people here. That's invaluable. I did not tell you the story of Terry Lewis, Craig Lewis, and Leanne because I wanted you to hear that story as it developed from the witness stand. What have you heard? Leanne and Craig knew each other first since high school. They're only months apart in age. He would hang out at their house. Craig dropped out of school and moved into the house with Terry and Leanne. Leanne went to college. Craig and Terry fell in love. They began a relationship. He continued to live with Terry for years until 27 when he married the love of his life, who was 23 years older at 49. And Leanne told you that she didn't stay much at the house since then. It may not be pretty. You may not approve. But that's the story. Now let's get to why we're here. We're here because Craig is charged with a horrendous crime, murder and arson. Craig represents the antithesis of why I still practice criminal law, because everyone is presumed innocent. They deserve a fair shot at life. They deserve to be treated fairly. They deserve representations that is guaranteed to them under our Constitution. They deserve to not have trash thrown at them and then wanting to turn it into evidence. They deserve not to be kicked. They deserve not to be boxed. They deserve not to be lied upon. January 17th, Craig rushes his wife to the hospital with serious burn injuries. This is where your common sense as a Walter Borough citizen. Everybody knows that Longleaf is where an Academy Road and all of that area near Colleton Prep is very close to the hospital. The hospital's on Robertson Boulevard. What would you do if your spouse is burning? Would you sit there and wait 5 to 10 minutes for the ambulance that's further away? Or would you jump, clothe your wife, since she's burnt her clothes, clothe her and get her to the hospital as quick as possible? That argument about him cleaning up, that doesn't make any sense. And I'll explain to you that further. They arrived at the hospital, from what Dr. Fisher says, uncontroverted by the state. Dr. Fisher says 12:14 is their arrival time. He doesn't say anything about that it looked to be old burn wounds, but yet they want to make it seem like Craig sat there for a long time. He says chief complaint, smoke inhalation, thermal burn. Then he says occurred just, not late, or appeared to be old. He said occurred just prior to arrival. Doesn't get any plainer than that. Then he says, it says her progression is unchanged, but this is the most important part. Context of onset of her injuries. She's painful. It doesn't radiate into her extremities, which means she doesn't have body injuries. Severe pain. Nothing wrong with her eyes. Patient denies any other symptoms. Now, why are we here when we have this statement? And I want you to take this back and read it. 63-year-old female with history of diabetes mellitus, hypolipidemia, hypertension, thyroid disease, presents to emergency department, complaining of burns onset, once again, to refute what the state has said, just prior to arrival. It doesn't get any simpler than that. Patient states, the patient trying to start a fire in the fireplace with the lighter fluid. Patient states, not husband, patient states the flame shot backwards and caught the patient and her clothes on fire. Patient admits diffuse pain. Patient denies eye pain or vision changes. There are no other complaints at this time. That's real simple. I don't understand why we're here with this statement. Why didn't the sheriff's department read this statement or ask to talk to the doctor? Then there was much ado about what happened after the doctor. At one point, one of the detectives even testified that, oh, he left the hospital quickly. Well, then we refuted that. I had to pull it out of Nurse Bishop, but she finally admitted that because I showed her where she is the one that witnessed at 1431 Craig Lewis's signature. Nurse Bishop is the one. So after the sheriff's department, if they wanted to investigate, saw that, this case should have been over. He didn't just leave as if he was hiding something. He stayed there. As a matter of fact, I was able to get it out of Leanne that he called her a couple of times saying, you need to hurry up, get here. Dr. Fisher talked about how he counseled. He read it to you. I counseled with husband and wife. He told you that after he counseled with them, wife agreed for her intubation. It was to protect her airways, and husband was agreeable to the intubation. Dr. Fisher testified that at 12:27, he intubated her, and it went well. He said after that, all he wanted to do was make sure she got to the Augusta Burn Center. That was the plan. And that's what Craig called and told Leanne. Leanne kept talking about Atlanta at that point, but it was an hour or so later when they had to change the plan because they got a call back from the Augusta Burn Center that, guess what? Unfortunately, the Burn Center in Augusta didn't have a bed. So then they changed course and had to fly her to Atlanta. With this written proof of accidental burn, and with Leanne getting there about 3 hours late after this, that's the first time. And after Craig left, we hear anything about this was not an accident. But the problem I have with that is that she didn't go to the doctor. She went to the nurse. Now let's talk about how and I made sure Dr. Fisher got into this because the state on opening, and you rely upon your memory, the state on opening said that Terry Lewis, I remember the state getting up and saying, Terry Lewis on the whole front of her body had third-degree burns. Dr. Fisher explains that third degree is the worst type. First degree is like a sunburn. Second degree is less severe. It wasn't until we got up that we find the consistency to prove accidental. He says she had the worst burns down here. Those with third degree, that's the only place she had third degree. And it wasn't on her foot. No burns on her foot, that wasn't wrapped. And the reason why I'm bending down is because what happens if you're burned on your foot, or not on your foot, what happens if you get fire caught right here? You bend over and you're trying to get the object off of you. And then what happens is, now this is where common sense comes in. Fire comes up. It doesn't go down. Fire rises. She's bending down, trying to remove the article, and that's when she gets burned up here. That's when the soot moves up. The state would have you think that lighter fluid doesn't cause fire to blow back. But I see commercials on that all the time. I've lit fires myself. It doesn't add up. It makes no sense. I've asked myself 5 years later, why are we still here with the evidence The only credible, written, unbiased evidence was done by the doctor. One thing I will give Leanne credit for is that she says that when she was in the room with Craig, some 3 hours later, he was sitting in the corner, couldn't talk because he was so distraught. She finally admitted that he was distraught. But the state won't bring that up to you. During the 3 hours, while they're waiting, during the 3 hours, not one nurse, not one PA, not Dr. Fisher detects that there's been anything but a horrific accident. In fact, when Leanne arrives, she describes, after she talks about my client being distraught, he tells her once again, your mom was messing around with the fire. I think he said playing around with the fire. And it went back on her. As they continue to wait in the room, Leanne concocts her own theory. By theory, she described from the witness stand, I was thinking it was a possibility. Well, we can't prove a case on possibility. I was thinking it was a possibility of what happened. She then goes and questions the nurse, and the next thing we know, law enforcement gets called. Things for Craig Lewis changed drastically. First to the hospital comes Shauna Tozier. She talks to Leanne, looks at Terry Lewis's feet, saw that they were clean and untouched, does not talk to the doctor. Wow. Does not secure the video from the hospital. Wow. Does not even interview the nurse or the PA who called. Wow, wow. Then Sheriff Andy Strickland immediately puts out a be on the lookout for Craig Lewis driving a black SUV. They go straight to his house within minutes. Brian Vonnerdo, who went to school with Craig, has known Craig all of their life. Along with David Long, Craig let them in the house. They walk in the house and talk to him. And the next thing I know, they want to know why you didn't call them. Why would you, if your loved one has caught themselves on fire, you're going to protect them and get them to the emergency room. You're not going to sit and call the police department for a fire. After they got their explanation from Craig, he goes to get in his SUV. They told him he could go. He went to get in his SUV. As he's getting in the SUV, he puts in the keys, turns it on, and they swarm on him. And Angela Stallings testified, finally I got it out of her, that she, now Craig is as big as he is, she leans into that SUV and leans over him, grabs the key, you ain't going nowhere. It makes sense. Get him out of the car. Well, why not just say, Craig, you need to get out of the car. We need to talk to you some more. No, get him out of the car. You ain't going anywhere. They swarm the back of the house. Within seconds, 12 deputies are there. When Angela gives the command, when she gives the command, they go to take this 6'6" man down any way they can, but they were trying to slam him next to his truck on the concrete. Craig wouldn't let them. He sidestepped and went down on the grass, and because he took those 2 steps to keep himself from being injured, they kick him and they box him. You know how you can tell he was boxed? This little state finally gave us that shows what happened. They had no information about what happened, and they did that to a person, a citizen in Colleton County. Then, after that happened, remember David Long in his testimony? Very evasive. He's the first one in the house. As long as it's Brian Varnado and himself, him and Craig can talk very easily. There's no problem. It wasn't until he missed that first swing that he was and gave Craig that he became invasive. He says during the takedown that he didn't want to show me his fist, but I finally got it out of him that he injured that. Angela Stallings told you Craig received a minor laceration. That is crazy. She still didn't put in her report that Craig had to be x-rayed at the hospital and checked out for the bruises and the kicks because of what happened to his back and his ribs. Right is right and wrong is wrong. A lie is a lie no matter what car it travels in. You should tell the whole truth. They had the medical records. You know why? Because when you're in custody in Colleton County, when you're in police custody, they take you to the emergency room. They get your medical records because the county has to pay for it. Because they kicked on him, because they hit on him, the county had to pay for that service. It doesn't make sense. And she calls it, oh, he just got a Band-Aid. You have to look at the demeanor of all, and your jury charge is going to tell you that. Look at the demeanor of all of their testimony. Not one was consistent. David Long says, I gave him his Miranda. Then I believe Kelly Paget came and said she gave him the Miranda. I don't know who gave him the Miranda. Nobody had a written Miranda form to get it signed out of their car, out of all of those cars. What I find most interesting out of this is Stallings says that she was over dispatch, but yet she did not preserve the 911 recording. Don't you think you would have needed that? They charged this man with murder and arson and didn't listen to the dispatch recording? Oh, come on. And she's the supervisor. She was trained, and she didn't think it was necessary to write a report for you? And 5 years later, we got to get her to think about what she said or create a story? She is the lead investigator. She didn't even go back to the hospital, not even 2 miles away from this house. She didn't go to the hospital and even talk to the nurse, talk to the PA, talk to the doctor. No, she didn't. And let me ask you this. From the witness stand, can you tell who was actually in charge of this investigation? I saw a lot of this. No, he was in charge. Jason Chapman said, no, she was in charge. I don't think they know who was in charge. You know why? Because they know they were dropping the ball. How about this? We wouldn't even be here today. If I am to believe 1/10 of what Leanne says from the stand, she says her mama was lucid, I think was the word she used, that after her mama stayed in the hospital in Atlanta and was transferred in May to the Charleston Hospital for rehab, she said her mama was lucid. Well, let's look at that. If her mama was lucid, and if the sheriff department wanted to get to the truth in this case, shouldn't one of those investigators have gone to Charleston? It ain't that far away.
Objection, Your Honor. May we approach?
Yes, let's go.
As Angela Stallings and Jason Chapman are sitting there pointing their fingers at who's in charge, Craig Lewis sat in jail from the 17th.
I'm sorry, can you rule on that? Was that sustained?
I'm sorry. We're talking about
We probably ought to do that outside of the presence of the jury if we're going to actually do that. Did you want to?
I want to proceed.
Okay, all right.
And I will start again. As Angela Stallings and Jason Chapman sat there pointing fingers at who should be in charge of the investigation, my client, Craig Lewis, sat in jail from January 17th to February 19th. He, if I go by what has been testified to, had already been Mirandized by 2 officers. Both Jason Chapman, after a little bit of prodding, finally admitted that they never even went over and talked to Craig Lewis to get his story. Perhaps the reason why Chapman and Stallings, as witnesses, were so defensive, at least appearing to me, is because they knew they dropped the ball. Let's look at Kelly Pageant and David Long. Their reports, too, are inconsistent. Does it make sense that both of them would have read Miranda rights? No. Sheriff Anley Strickland goes to the hospital, talks to Craig, and finds the couch that he instructed someone to take to the dump, that Craig had previously had someone to take to the dump on the side of the road. Does this sound like Craig not cooperating? No. They confiscated Craig's phone. Did they bring you the evidence of what they confiscated? Because if so, then they would have been able to go in the phone, dump it, get the information, and backtrace on who Craig called to move the sofa as he's sitting there with his wife. We have to think of common sense. They could have found out, they would have found the text and everything. But we don't have that. I don't have the burden of proving anything. He went from the couch and helping them find the couch to lock up. There has been much ado about this burnt couch. Why is the couch so important? I don't know. Who would keep a burning couch or a couch that has been burnt in their house if they know they're going to be in Atlanta with their wife for fear that it will reignite and burn your whole house down? Doesn't it make sense that he's trying to get ready to head to the burn center in Atlanta? Who carried the burn sofa away? Sheriff's Department had the ability to have that person here. And why they put it where they put it, why they put it, it has nothing to do with this case. They confiscated not only Craig's phone, they confiscated his wife's phone. But yet they didn't put any of that in the evidence. And coincidentally, when you became jurors in this case, that's why I asked, do any of you look at crime shows? 31 days in lockup. Many officers involved in this case. Crickets. Now, you've seen a lot of evidence. All of this evidence here. Look at this sofa. Look at the sofa. Look at the one they got off the side of the road. Look at the blanket that has the smothering burn on it. They didn't test any of that stuff. They knew they had the burden of proof. This sofa has not even been tested to see if it had lighter fluid on it. Who would burn their wife sitting on a sofa and throw it on their legs first? That's the only part of the sofa that's messed up. I heard some talk of the door to the fireplace being closed. I didn't enter this in the evidence. They did. They collected the sofa inserts off the side of the road in the blanket. You remember Officer Chapman, I had to get him to admit, oh, there's white cotton that looked, and if you look a little bit closer, you'll see the singe marks. Did they test that? Now, the other much ado in this case, I will admit, I was like, where would blood come from? Then it made sense. Dr. Fisher said, no, you don't find a lot of blood with burn because it cauterizes. So, but they test the blood prints, bloody footprints, doesn't have anybody here to tell us how old those bloody footprints were. Of course it's her blood. She lives in the house. She has a lot of medical issues. They don't say when they occurred or how they occurred. They just want you to live on probably, maybe, this how I think it happened. That's not enough. And you know, they talk about this case being an old case, yeah? Well, it took me asking Miss Lacey, or Lacey, I'm not sure how to pronounce her name, that did the DNA. They took the swabs of her, Miss Lewis's DNA when she died on November the 3rd at MUSC. That's when the pathologist collected it. You know when Miss Lacey said she got the swabs to do the comparison? In 2022. All while Craig is languishing. They didn't worry about it. Somebody dropped that ball too. They didn't realize, I believe, that Dr. Fisher would talk about the cauterization of blood. They didn't realize that Shanatoja went to the hospital and saw a clean, untouched foot. They don't realize that you know that the burden is on them to bring a nurse here or bring a doctor here that says, I cleaned off her foot. I cleaned blood off of it. They could have gotten the nurse's notes. They didn't realize you understand when they clean your foot or they clean blood off you, it's usually some type of iodine that will leave a color. She said clean, untouched foot. The wood burning stove. Let me show you what I put into evidence. This is really crazy. Here is the picture. That's defense exhibit number 5. The door is clearly open. There is clearly a lighter fluid can on top of the stove. And yet, no one testified from that witness stand. And it's sort of embarrassing to me. Do you mean to tell me, Colleton County, no one out of those 12 people that came to the scene doing investigations, nobody knows how to lift fingerprints? They didn't even bother to lift fingerprints off of this lighter fluid can. I could bet you if Craig's fingerprints were on there, you would have been presented with that evidence. That's just unbelievable. And yet they come here and try to show you pictures of a closed door with some debris. As old as this house looks and as old as this stove looks, they can't tell you when that debris was put there or what happened. They didn't even bother making an attempt to bring you a cause and origin expert. The burden is on the state. They didn't even bother to get someone from the fire department to come and say, hey, this is my specialty, this is what I do, I determine fires, this looks like it's been set this long ago. No. They just want to call Craig a murderer. Then they said, oh, we felt the log. What? You felt the log? And you couldn't get in the house until 5:30, pursuant to the search warrant. If all the fire blew out, there's none going to be in the fire. There's much ado about residue from the house. They didn't even test it, so I don't know why they testified to it. I saw even one that looked like there was dog urine. They talked about that on the floor. I don't understand. You have here some bags. You got a bag which appears to be jeans. They just threw it in to evidence. Didn't test that either. Another bag which appears to be jeans. And she says the reason why she put this in is there was debris on the bottom of the pants leg. So which one was he wearing? They hadn't tested that either. But yet they talk about burn pits he had at his other house. Perhaps it came from that. And wouldn't you expect stuff at somebody's house? They want you to figure out which one is real evidence, because we know he wasn't wearing 2 jeans. We don't even know what he was wearing. Why are we here? The only written evidence we have that an accident happened came from Terry Lewis's own statement to medical experts. This is an accidental burn. This is not an arson. This is not a murder. We're here only because of speculation and possibility. Leanne is the real reason why we're here. No one has shown you how Terry was burned or when Terry was burned. No one has shown when Craig got to the house. Just that he got there in time to save his wife. In order to get to why Leanne made these allegations and why after 5 years Craig is still facing arson and murder charges, I had to go where they say you have to go sometime. I had to follow the money. Follow the money, sometimes you'll find people's motives. The check. I know we live in a digital age, and I know most people don't get their checks. But we have a check here that is Exhibit 6. Says January 15th is the date of the check. It's written to Leanne Kellum, $1,200, with a scribbly signature of Leanne's mother, Terry Lewis, signing it. The same mother who Dr. Rankin said had tremors. In November, she had tremors. I submit to you to think about this. This check is on the 15th. Leanne says she was there to their house on Kansas City on the 16th. Everything's copacetic because she's needing money and wanting $25,000 and wanting him to put the house in her name, in his name. Why then would that little story she told about why she wrote this check the day before and that her mama was planning on leaving Craig, why would they do this on Tuesday? She go to the house, this check it would be on Tuesday, January the 15th. She goes to the house on Wednesday. She's texting back and forth, and she's trying to say her mother did this on Tuesday knowing that she was leaving for Leanne to get her some money so that she could help her mama get out of the marriage. But yet, this is what's telling. Leanne does not cash this check until January 23rd. That tells me that she predated a check to make it look good, but she didn't realize she would have to testify to being up there and up there at the house the day before. Makes no sense whatsoever. Follow the money. I wouldn't blame the state. I wouldn't blame them not wanting me to get into the fact that Leanne within days of her mama's burning, accidental burning, froze, attempted to freeze Craig's assets. She knew that Craig had inherited cash and that it was in a safety deposit box. She had it frozen by the court when she did her conservatorship. They didn't want me to get into it. Here's the order. It's for you to read. The order is real clear. While she was conservator over her mama's estate, $4,454.90 in expenditures she couldn't account for, and $1,832 of expenditures went to other people, not Terry Lewis. Even though she says she's got reasons why she did it, now she says her mama wanted her to do those things. Who thinks of doing a GoFundMe 4 days after something horrific like this? Who thinks of that? Here's that. She got the money from that, but because it was in reference to a crime that she was alleging, I wonder why she had to take it down. What's disturbing to me is when asked about the life insurance policy, the life insurance policy was paid for from their joint account, Terry and Craig's joint account. She tells us that her mother was lucid enough to tell her in May of 2019 that, yes, Leanne, you deserve that money. Go and change that $25,000 life insurance policy to yourself. And you saw her expression. That's when she crossed her legs and said, yes, Mom told me to change it, move Craig as beneficiary and put myself as beneficiary. Shortly after us, May, the same May that the life insurance beneficiary was changed, the do not resuscitate was signed by Leanne. And then she starts talking about how Mom lost the will to live, would not get out of bed, stopped getting out of the bed, developed pneumonia and bed sores. She says big enough where you could put a fist in. Had to be sent back to Augusta Nursing Home by November 1st. Craig's wife that he took care of. He took care of her through bipolar, dementia, tremors, double mastectomy. He stood by her. Craig's wife, he wasn't able to see her from the time he left Colleton Medical. He has never seen his wife again. Never. His life was forever changed. That was a 25-year investment. Perhaps she didn't want Craig to be with her mother, but that's who he chose. She died, never seen her husband. Perhaps she would have been able to thrive if she had him. Because she, from the witness stand, said that her mother got better from the burns. So if her mother got better from the burns, why are we here on murder? Doesn't make any sense. Her mother got better from the burns. She went back to have a neck adjustment. Allegations of the abuse the night before. Let's unpack that bag. What daughter would allow their mother to be treated in the way she described without defending her and, more importantly, calling the police? That is the craziest allegation I've ever heard. Here's the abuse if I listen to what she says. Mom is waiting outside of a dark trailer at 2 o'clock in the morning. I had to elicit from her that Mom was actually sitting. Where are the 3 dogs? She doesn't talk about that. She arrives, takes her away, and turns around to get her keys and wallet. First she said keys and medicine. And then after I asked her about her statement, then she says keys and wallet because she needed to buy cigarettes. But before she said she usually buys her mama her cigarettes. Mom beats on the door and Craig comes to the door, slings the door open, pushes Mom down this long ramp, the ramp he made for her because she was falling a lot. You see how long that ramp is? Mom lands on the dirt, which means he would have had to push her with such violent force that she would have tumbled over or whatever. There is no way that you can even buy her story because that is a long ramp. When I asked, where were you parked when you saw it? Because she says it was dark. Oh, yeah, I guess around here. Okay. I drove around there. Well, here's what you do. You look at what her vantage point is. Then when she realized where the next question was, she said she got out. What daughter would stand there and let somebody slam their mama's hand in the door one time? What daughter would stand there and let somebody grab their mama's face and slam down into a grill? And coincidentally, if you look at the picture, if you got the door open, you can't get to the grill. While Brian finds me State's Exhibit 48, I want you to look at that and tell me, imagine this at 2 o'clock in the morning in her story she gave. First, the other thing she said on direct examination, and I want you to remember her body language. I made note of the fact that at that point, her legs were crossed. Her body language changed. I asked her, how many times was this? How many times was the fall? He pushed her down 3 times and you didn't grab your mama who was apparently having a manic or some type of problem? I'm totally befuddled by it. I want you to look at the grill. Is there one with the ramp? When I asked Leanne about the falls, she said it was 3. She said he pushed her down. And I said, well, where did she land? Because I wanted to know, he built this ramp for her because of her problems. I wanted to know, where did she fall? On the dirt. Well, look at how long that is. Then he supposedly, and Leanne says she was there. I don't know whether she was on the ramp or there, but I don't have the burden. There's a grill right there. She says that Craig slung open this door. If you sling open the door, oh, come on. Who's going to stand there and let him? He would have to put her head around the door in order to slam it. Don't let anybody insult your intelligence. This makes no sense. No police report. What daughter is going to allow their mother, who is frail, who has all of these problems, to be attacked? And just hours before, you were there asking for $25,000 and a house to be put in Craig's name. I don't know. What daughter wouldn't take their mom, who's such a frail person, to an emergency room? You know she's got problem with instability. You know she has like 9 different chronic health conditions. She's 63 years old. Her head has just, if I go with you, has been slammed into a grill. What daughter would not take their mama to the emergency room? Come on. Was the money more important than mama? Let's talk about Terry's medical condition. Leanne sat right there and said, oh, the tremors had resolved. Well, Dr. Rinkin said in November she still had the same medical problems. Falls, tremors, dementia. She had the 2014 incident was where she had lithium toxicity and was in the hospital also with falling. Then he said she has a chronic condition of hypothyroidism. That causes you to be laggy and it causes you to fall sometimes. But most importantly, Dr. Rinkin, who has been treating her since 2010, says that he said that Terry reported when she had to stay in the hospital on the 4th floor and have the psychological eval, the report that he got, they asked that specific question of any of their patients. And he said the report that he got said Terry had never reported any form of abuse. If the state wanted to give you the truth, wouldn't they have found? Before I believe in believing in my client, it helps me fight harder for them. First thing I did was subpoena the sheriff's department and the police department ad infinitum. I want any allegations of abuse. Show me all incident reports coming out of Terry Lewis, Leanne, and Craig. We found reports of other stuff. Nothing regarding any criminal domestic violence, and he's not charged and never been charged with criminal domestic violence, nor has Terry been charged with criminal domestic violence.
Objection, Your Honor, arguing facts that are not within the record.
Let's come around here for a moment, thanks.
As all of the officers came here to testify, not a one testified that Craig Lewis, prior to January 17th, 2019, had ever had a criminal domestic violence. Same thing for Terry. So why are we to believe Leanne? Do you believe Dr. Rinkin on her medical condition or Leanne? Do you believe what Leanne said about Craig's infidelity? Wouldn't Leanne know best whether that story is true? One thing is certain, her relationship with Craig and her thirst for money gives her the motive to lie and concoct a crazy story that we've heard and get him arrested with hopes of him going away and her getting the the money. Follow the money. In closing, think of this. There is no way this 6'6" man would burn his wife on her legs to kill her. All those medications she was under, there are many, many ways he could have done that. Why would he kill her? I don't know whether you heard it or not, but when they were talking about the clothes that was taken off Miss Terry, they had to cut her clothes off her. And Terry was so sick, she was wearing Depends. Why come in here and say this was all third-degree burns when you know, with a little bit of checking, that the worst burns were down bottom? What makes sense? How can he would have had to get on his knee. For 6'6", he would have had to get on the floor to throw something on her or set her on fire. She says, oh, Terry always sat in that chair. They got 3 dogs. Look at the chair. Look at the pictures of the chair. And then she said, I don't go over to the house that much, so how can she testify to that? Where Terry sat. It makes no sense. It makes sense what Terry said. The records don't lie. When she bent over trying to get her clothes off, the fire spread to her face. She probably ran around freaking out. It makes sense that she, having tremors, smoking cigarettes, she's shaking. Some of the lighter fluid got on her pants leg, and then when she lit the fire, it blew back on her. Common sense. And she can't get around that well, so she probably stumbled over to the couch. What does make sense, though, is that Terry Lewis loved Craig, and Craig loved Terry. He loved her so much, she burnt her clothes off. He made sure that she was covered enough and got her into that hospital. Do we have an arson? Do we have a murder? We have only an accident and a miscarriage of justice to my client, Craig Lewis. His wife is gone. And all they seem to care about is getting a pound of flesh.
Yes, ma'am.
This is no love story, as the defense would have you believe. It simply is not. It is a nightmare. Being burned alive is a complete nightmare. What would you do if your spouse is burning? Not change clothes before going to the hospital. Maybe call someone with some medical training so that they can remove the clothing from burning flesh. That's why the hospital cut the clothing off of Terry that she came in with, the non-burned clothing, because they didn't want to further injure her. Let's see. Reports don't testify, okay? Doctors and nurses testify. You listened to them testify. Whether or not police talk to those nurses or doctors, they talk to you, so you have that information. Does this look like a stove that flames just came out of? No, it doesn't. And why wasn't this fingerprinted? Why wasn't that fingerprinted? Why wasn't DNA done on this? Because this is in Terry and Craig's home, where their fingerprints would be all over, where their DNA would be all over, because they lived there. DNA fingerprints would prove nothing, because you can't tell when DNA was placed there, nor when a fingerprint was placed there. Ms. Bright Matthews wants to argue that Craig was distraught. Well, I think Leanne also described the word panicked when she described what he was like, when his demeanor was like. Panicked, because he knew, oh boy, this does not look good for me. Let me make some arrangements to get that couch out of here, because that doesn't look good. Also, let's talk about the grill. Seems to me, unlike what Miss Matthews told you, that you can actually open the door and get to the grill. So you make that determination. She talked a lot about how Craig was the victim of a police beating. There is no evidence of that. None of these officers testified that they kicked or punched him. He was failing to follow their commands to get out of the car. He was being detained. He did not want to be detained. He is a huge man. They got him out of the car. They took him to the ER. Dr. Fisher told you that he had a scrape on his face, that he complained about possible internal injuries. They x-rayed him. The x-rays were clear. They sent him on to the jail with a couple Advil. He was fine. He is not the victim in this case. I believe Miss Bright Matthews mentioned that residue from the house that was on the floor was not tested. It was. It's in these cans. Agent Tang testified to it. Unfortunately, it just didn't tell us very much, because if there was any ignitable fluid, it could have been evaporated, but we talked about that already, and use your common sense. She wants you to follow the money. Well, if you listen to her version, it sounds like Leanne should be on trial for murder. That she was so greedy that all she wanted from her mom was money, money, money. Craig is on trial for murder, okay? Follow the money. Craig screamed at Terry the night before he burned her alive. You are a cheater. You will get nothing. So, let's follow the money. I'm asking you to return a guilty verdict for arson and murder against Craig Lewis. Thank you.
Thank you so much. We're going to take up a brief matter of law outside of your presence, and then I'll bring you back in for the charge. So if you would take them all back, thank you. Cold, hot, cold. See, I'm wearing a coat, so you know. Thank you. We had 2 objections during closing in both of those cases. I think the timing of the objection and Ms. Bright Matthews stopping with the comments at that moment may very well have cured it. I'm concerned if I give a curative instruction with regard to those 2 things to the jury, that it'll be more confusing than helpful. Anything from the state on that?
I don't want to draw any more attention to it. I just do want to say that that was completely improper for the defense to ask the jury to consider why police didn't go interview the victim when they actually did, and that was not admissible because it was hearsay, and the defense did not want that in.
Well,
and then they want to argue
let's do
that
this.
that
Wait,
statement
hold
is
on
not
one
in.
second. I ruled in your favor on the exclusion of it, and again, I think we stopped it in a timely fashion. So I think that probably handles it, because again, I think you even agree to deal with it further might confuse the jury.
Thank you, Your Honor.
Thank you. Ms. Bright Matthews, anything on that subject?
Nothing other than what, in essence, we discussed in sidebar. The issue of lucidity was elicited from the stand by Leanne Kellum, and the issue regarding the interview that she's referring to does not relate to any officers with Colleton County that have jurisdiction here.
Okay, thank you for your comments. And let's see, now that this has been handed back to me, has there been a change or?
It was just the formatting, it's
Oh, the
just
formatting.
the correction that we.
Okay, so I've been handed what I believe is the jury charge that everyone agrees on. Again, I understand the spoliation motion from earlier, which is on the record, my denying the defendant's request for that. So I think we are probably ready. Anything before we bring the jury back in for the charge?
No, Your Honor.
All right, can you bring them back in, please?
I just said nothing.
Okay, thanks. Oh, okay, all right. No problem. Tell them to take their time. It's all good. Thank you. Okay, get comfortable. This may take a few minutes. I'm now going to read you the charge. Ladies and gentlemen, it is now my duty as the trial judge under the Constitution of this state to charge and instruct you on the law applicable to this case. It is your duty as jurors to accept and apply the law as I will now state it to you. Furthermore, it is your exclusive duty to decide all of the issues of fact in this case and to determine the effect, value, and weight of the evidence. Both the state and the defendant have a right to expect that you will carefully consider and evaluate the evidence and apply the law of this case to it so that in the end, both the state of South Carolina and the defendant will receive a fair and impartial trial. I want you to understand that when I use the word defendant, I refer to Mr. Craig Anthony Lewis, Furthermore, it is important to understand that the state of South Carolina charges the defendant with the offenses known as arson first degree and murder. To this charge, the defendant has entered a plea of not guilty. To these charges, the defendant has entered a plea of not guilty. The plea of not guilty places the burden of proof on the state to prove the guilt of the defendant to you, the jury, beyond a reasonable doubt. I remind you that the fact that the defendant was arrested, charged, and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. The indictment is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court. Now, during this trial, you and I have separate duties to perform. As the trial judge, it is my responsibility to preside over this trial, and I also have the duty to rule upon admissibility of the evidence offered during the process of this trial. In that regard, you are to consider only the competent evidence before you and are to disregard from your mind any testimony ordered stricken from the record in this case during the progress of the trial, if there was any. And you are to consider only the testimony which has been presented from this witness stand, together with any exhibits admitted into the record of this case and any stipulations of counsel made into the record if there were any. Furthermore, I have the additional duty to charge you on the applicable law of this case, and in that regard, I am the sole judge of the law of the case. It is your duty to accept and apply the law as I state it to you. If you have any preconceived ideas of what the law is or what the law ought to be, and it does not agree with what I tell you the law is, you are obligated under your oath to abandon these preconceptions because you are sworn to accept the law precisely as I state it to you. Ladies and gentlemen, in this trial, you are the sole and exclusive judge of the facts, and I am the judge of the law. Do not infer that I have any opinion about the facts in this case from anything I have said during the course of this trial, in ruling upon the admissibility of evidence or otherwise, or from anything that I say during the course of this charge to you. In this regard, the law simply does not permit me to have an opinion about the facts. As jurors, it is your duty alone to determine the effect, value, and weight of the evidence presented during the course of this trial. In determining what the facts in this case are, you must judge the credibility, which simply means the believability of the witnesses and the value or weight to be given to their testimony. You alone must decide the force and effect of the testimony. In making this decision, there are many things you may and should take into consideration, such as the appearance and manner of the witness on the stand, a characteristic often referred to as the demeanor of the witness. Was the witness forthright or hesitant? Was the witness testimony consistent, or did it contain discrepancies? What was the ability of the witness to know the facts about which he or she testified? Did the witness have a cause or reason to be biased and prejudiced in favor of the testimony he or she gave? Was the testimony of the witness corroborated or made stronger by other testimony and evidence, or was it made weaker or impeached by such other testimony and evidence? As jurors, please understand you have the right to believe a small portion of a witness's testimony and discard a larger portion, or vice versa. You may believe all of a witness's testimony or none. You may believe the testimony of a single witness against that of many witnesses, or the other way around. In exercising your mental processes and attempting to decide the verdict, the law simply requires that you exercise your good judgment, your common sense, your sense of logic and reason, and your experiences in life. You then apply these attributes to the evidence and apply the law as I state it to you, and thus arrive at a verdict. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. A witness who, by education and experience, has become an expert in some art, science, profession, or calling may state an opinion as to the relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received as evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education or experience, or if you conclude the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness simply because the witness is an expert. Further, you are not required to accept an expert's opinion even though it is not contradicted. It is vital to understand that the defendant is presumed under the law to be innocent of these charges. The defendant has no obligation to prove his innocence. It is a fundamental rule of our law that a defendant, irrespective of the seriousness of the charges against him, is always presumed innocent of the crimes for which he is charged, unless and until his guilt has been proven by evidence that satisfies you, the jury, beyond a reasonable doubt. The presumption of innocence is not a mere legal theory or legal phrase. The presumption of innocence is very important, and you need to understand that this presumption accompanies the defendant from the time of his arrest and appearance in this court and continues with the defendant even after you retire to the jury room to deliberate. In other words, the defendant receives the benefit of the presumption of innocence until the very end of this trial, when you, the jury, will deliberate upon the evidence and decide whether the state has proven his guilt beyond a reasonable doubt. Ladies and gentlemen, what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, so even in criminal cases, the law does not require proof that overcomes every possible doubt. However, if based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. Jurors, please understand that reasonable doubt may arise from evidence which has been presented in the case or from lack of evidence in the case. It is your responsibility to determine whether or not reasonable doubt exists as to the guilt of this defendant. I charge you that the defendant is entitled to every reasonable doubt arising in the whole case. If upon any issue of fact essential to conviction and a verdict of guilty, you have a reasonable doubt as to how that issue should be resolved, it would be your duty to resolve that reasonable doubt in favor of the defendant. Thus, in summary, it is important to understand that a defendant is not required to prove his innocence. Instead, the state is required by law to prove every essential element of the offense charged against the defendant by evidence which satisfies you of his guilt beyond a reasonable doubt. Only then can you convict the defendant and find him guilty. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If the circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. I instruct you and emphasize that the fact the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or innocence of the defendant. It must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant in this case did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There is no way to prove intent to a mathematical certainty. There is no way medical science can dissect a person's brain and determine what the person had in mind, so the law says that criminal intent may be shown from the circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established in the same way as any other fact by taking into consideration the acts of the parties and all of the facts and circumstances in the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with arson. The state must prove 3 elements beyond a reasonable doubt to establish arson. Number 1, willful and malicious act. Willful means intentional, that it was not done by accident. A willful act is one done voluntarily and intentionally with the specific intent to do so. I will read that again because I made a mistake that I corrected, but I'll read it again just to make sure. Willful means intentional, that it was not done by accident. A willful act is one done voluntarily and intentionally with the specific intent to do so. Number 2, burning that results in damage to a building, structure, or any property specified, including personal property. The burning must result in damage to the building, structure, or property. It is not necessary that the building, structure, or property be consumed or destroyed, only that it be damaged. The burden is upon the state to prove this beyond a reasonable doubt. Number 3, death or serious bodily injury. The state must prove beyond a reasonable doubt that the death or serious bodily injury to a person resulted either directly or indirectly from the willful and malicious conduct. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury. It is an evil intent. Malice is wrongful intent to injure another person. It indicates a wicked or depraved spirit intent on doing wrong. Malice is a legal term implying wickedness and excluding a just cause or excuse. The term malice indicates a formed purpose and design to do a wrongful act under the circumstances that excludes any legal right to do it. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be express or implied. These terms, express and implied, do not mean different kinds of malice, but merely the manner in which the malice may be shown to exist, either by direct evidence or by circumstantial evidence from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other act of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be shown from conduct showing a total disregard for human life. Ladies and gentlemen, I want you to clearly understand that you are not partisans or advocates for the state of South Carolina or the defendant. It is your duty, by your joint deliberations, to determine the facts in this case, giving the defendant the benefit of every reasonable doubt on each and every issue. Then, to the facts which you determine to be true, you should take and apply the law which has been given to you by this court, and thus arrive at a verdict in this case. Thus, when you have accomplished these responsibilities, you will have satisfied your oath as jurors, and you will have discharged your duty to this court. Once you retire to the jury room, the bailiff will give the verdict form to the foreperson. When you, the jury, arrive at a verdict as to the offenses charged in this case, the foreperson will select the verdict as to that offense on the verdict form. If the state has failed to prove the guilt of the defendant beyond a reasonable doubt, your verdict will be not guilty. Likewise, if the state has proven the guilt of the defendant beyond a reasonable doubt, your verdict will be guilty. Once a decision has been made, the foreperson will check whichever choice is the verdict of the jury as to the offenses charged. The verdict that you render in this case must be the verdict of each and every juror. It must be your unanimous verdict. All 12 jurors must agree on the verdict which you authorize the foreperson to write for the jury. Ladies and gentlemen, I want you to further understand that the order in which the choices of the verdict appear on the verdict form are not suggestive of any verdict on part of this court. The verdict in this case is to be determined by you, the jury, not the court. Furthermore, ladies and gentlemen, please understand that even though I will give the verdict form to the foreperson, it is not her verdict alone, it is the verdict of all 12 of you. And I emphasize again, it must be unanimous. You must consider the instructions as a whole and not follow some and ignore others. I now ask you to please retire to the jury room, but do not begin your deliberations until you are told to do so. The law requires that I now consult with the attorneys to make sure that I have not left anything out of these instructions. After I have checked with the attorneys, the bailiff will bring in the verdict form and instruct you to begin your deliberations. Also, should you have any question during your deliberations, you must put them in writing and send them to me by the bailiff. The court bailiff will be placed immediately outside of the jury room during your deliberations. If you have questions, please do not write the breakdown of your vote on the paper that you give the bailiff. Once you have reached your verdict, please knock on the jury room door and ask the bailiff to advise the court that you have reached a verdict, and we will return to the courtroom as promptly as possible. We will return you to the courtroom as promptly as possible. Thank you, ladies and gentlemen. You may now retire to the jury room, but again, do not begin your deliberations until you have been advised to do so. Thank you. Bailiff, would you please separate the alternates into a separate room than the jury room at this time? All right. Other than the spoliation issue that we took up later, which I think is on the record, any comments?
No exceptions to the charge or the jury verdict form.
Thank you.
None from the state, thank you.
All right. The charge that I was going to send back with them, when I read, sometimes I draw. So I'm going to get a clean one. We have a clean one? All right, I'm not going to send this one with blue marks that may indicate one part's more important than another. That's just my doodling as I draw. You've got a clean one, right?
I do. The format's a little messed up on this one, but it's the exact same thing you just read.
Okay, the format is slightly different on this one. Same words, though. Any objection?
No objection.
Okay.
It's just got spaces.
Can I have a copy for my file, a hard copy for my file?
Yeah, let's do that right now. Let's make a
What's
couple
going back?
of what's going back. Let me see how many marks I made on this one. Maybe I can just take one of your pages.
Yeah.
I think it was mainly,
Just take your pen.
you know what, do you have page 19? If we can replace page 19.
That's the one we just printed, yeah, okay. Yes, no, because it goes over to the next one. Here you go. I can just have it printed real quick. Can you? You also need the parties to agree on the evidence.
Right, thank you. So do we have a 19?
I'm going to print it for you.
Okay.
We usually get together the exhibits. This time, I think because there's pants and different things, we might need to send back gloves.
Gloves, that's a good thought, thank you. By the way, what we're going to do is not use the bad format one. I'm just going to get a new 19, which is really, I thought I had marked up more than this, but I didn't. And I just made a little squiggle right there. But nevertheless, I'm going to take it out. We'll replace the page 19 with an unmarked page, and then the one that will go back to the jury will be exactly what you all already have. Save us from printing 100 copies here.
You've got two defendants, 7 and 8.
What are you saying?
This is 7 and 8, and this is.
Yeah, we can be off the record from it. Have all counsel had an opportunity to review and confirm that the exhibits are the exhibits that were entered?
Yes, Your Honor.
Actually, I didn't. I noticed I shouldn't, but give me a second to review.
All right, take a second.
I just reviewed mine.
So, if the jury's coming in like noon or something, I could do, I'm going up Monday night, so I could, but if the jury's coming in at 9 or 10, I don't want the jury to sit there because it looks like a really complicated. And if those guys on this.
I've reviewed all of the state's evidence was presented at trial.
All right, good. First, is there any objection to releasing the alternates?
No objection from the state.
I'm going to instruct the alternates that they're welcome to leave and please not discuss the case with anyone until they have heard the verdict, which they're welcome to call back in, or if they would like to simply remain with us, they can sit in the back of the courtroom. Is that
Yes,
acceptable to all?
Yes, sir.
For the jury, for the alternates.
Wait, say that again.
The jury, the alternates.
The alternates have lunch coming for them, so I'm going to instruct them if they want to stick around for a few minutes, they can get their lunch, which they can eat somewhere in the courthouse if they want to stay, just not in here, and or they can get it to go. All right. Let's see, could you bring the alternates in then, please?
Okay, is it supposed to be here?
But not yet. Let me get the alternates taken care of. I know it's hard to hold all that stuff. Did we get the latex gloves to go back there? Okay.
The clerk's going to check to see if the food's here yet, but it should be here soon.
Okay. Gentlemen, you don't really need to sit down or anything. I wanted to thank you very much for your service. It seems like you're not going to get to do a lot because you're not going to get to deliberate, but without your service, without your being there, we could not have proceeded with this trial. So your efforts, your participation was every bit as important as anyone else that was on this jury. Now, the important thing you're probably wondering about is I ordered lunch. What's going to happen? Don't worry. They're going to bring your lunch to you. I think they're going to check and see if it's here already. You are free to leave, of course, and they'll put that lunch in a bag for you and you can go. If you would like to stay until the rest of this trial, you're welcome to do so. You can just sit in the back, and obviously, as any member of the public, don't say anything or do anything. I would ask you not to discuss anything about the trial until the verdict has come in. And then you are free to do so, like any member of the public, anyone that's been on the jury. The public, however, is not free to contact you if you do not want to be contacted. So if you have that problem, if people contact you and say, I really want to talk about this, and you say no, then, and it becomes a problem, please contact the local clerk of court here and they'll get in touch with me right away and we'll deal with it. No one should really know what your names are or addresses or anything because we've referred to you by community. So I'm sure there are people out there who would recognize you too as you wander down the street. Do you have any questions, either one of you?
No, sir.
Anything to add before I release them from counsel?
No.
Okay.
Nothing from the defense.
All right. We haven't found out about the lunch yet.
She just went down and checked.
Where can these guys go to, is there a way to go down that way? Okay. Maybe y'all could go down to the lobby and figure out what happened to lunch for you two. And again, don't bring the food back in here, but if you're welcome to come back in after you eat if you wanted to do that. All right. Thank you very much for your service this week. Okay, as soon as they're clear, anything from council before we begin the deliberations?
No, Your Honor.
All right, as soon as they're gone, if y'all would please take the exhibits to the jury and the verdict form and the charge, which I think you have in your hand there, and ask them to please begin deliberations. All right. Anything else for the record before we go off the record for now? All right. We'll be off the record. Thank you very much.
It's on the way.
Rise for Honorable Judge Dukes, preside.
Y'all be seated, thank you. Let's see, we need all our counsel back, I guess.
We are locating defense counsel. We actually, Kate went to see if they're in the conference room. And I've notified my victim advocate, we need the victims back up here too. Shannon?
Bring in the jury if you would, please. Thank you. Madam Foreperson, do you have a verdict?
Yes, we do.
Could you please hand the verdict form to the bailiff? Thank you very much, sir. Thank you. Madam Clerk, can you publish the verdict? Thank you.
In the case, State of South Carolina versus Craig Anthony Lewis, indictment numbers 2019 GS 15 00138, charges arson in the first degree. Indictment 2019 GS 15 00129, the charge is murder. As to the charge of arson first degree, we, the jury, find the defendant, Craig Anthony Lewis, not guilty. As to the charge of murder, we, the jury, find the defendant, Craig Anthony Lewis, not guilty. And this was signed by the foreperson on today's date, November 7, 2020.
Thank you. Would either party like the jury to be polled?
No, Your Honor.
No, Your Honor.
All right. Thank you. Members of the jury, thank you very much for your service. Our entire judicial system could not function without people like you who are willing to give up your free time, your time from work and family to come in and make these difficult decisions. I thank you for your attention. I thank you for your hard work. I know it was a difficult decision for all of you to sort through all of that information, all that you heard, all that you looked at, and come up with a verdict. And I appreciate it. If any of you want to discuss any of this with me, you're welcome to give me a call at some point. Can be found in the Beaufort Clerk of Court, through the Beaufort Clerk of Court. You are welcome now to go discuss this case with anyone that you would like. You're not required to, however. If anyone begins to bother you or harass you or anything about your verdict, please contact me through the Colleton County Clerk of Court's office immediately, and we'll have it taken care of. Does anyone have any questions? All right then, I would thank you all for your verdict. Any objection to releasing this jury?
No, Your Honor.
None for the defense.
Thank you all very much. Anything else from the parties?
Yes, Your Honor.
Yes, ma'am.
Defense would move to have the arrest warrants and all issues in reference to these indictments against this defendant expunged by the court.
Any objection from the state?
No, I believe there's a process for doing that.
No.
But, okay.
If a case is tried, then the defendant has an opportunity to have it done. If we wait till a process, there's a cost.
Granted, I'll be happy if you'll get the forms to me to take care of it.
Second, Your Honor, the defendant has been on ankle monitoring under a bond since February 19, 2019. Defendant moves to have that ankle monitoring.
He is released from his bond and the requirements immediately.
Third, Your Honor, there is a number, quite a bit of personal property that was seized pursuant to these warrants and indictments. Defense moves to have an order from this court requiring the Sheriff's Department to return those items to the defendant.
The items
They can have the sofa.
Right. The trailer, I'm assuming is what you're
Yes,
talking about.
the trailer, even the pants, his, all of his personal property that don't relate to any arson, like the lighter fluid cans. We don't want that, but the rest of his personal property, we believe he's entitled to.
Well, from what I saw, you're probably talking about the trailer, the 2 pairs of blue jeans, and what else? Was there anything?
There was a piece of a gun, or some guns, or something along those lines. But that's why I just said personal property, and we can work that out later. He wants his trailer, for sure. He can do without the pants, but he wants his trailer.
Who, Madam Solicitor, would be contacted to?
You can contact Steve Basil with the Sheriff's Office. He's in charge of evidence, and he can wait around and we can give Miss Matthews the 2 pairs of jeans that were in evidence. We don't need them. So,
Your Honor,
have his foot jeans back.
I appreciate that from them. However, in the past, there's been some difficulty retrieving things. It takes, so unless we have an order from the court requiring that they return the trailer.
So Ms. Bright Matthews can submit an order with what she likes, and then she can take that to the Colleton County Sheriff's Office.
I'm sorry, Your Honor. I did not mean to interrupt Ms. Swanson. An order from this court can be by Form 4 and direct, just return his personal property, and that's all.
And that's fine. If you'll prepare that order, I'll be happy to. I'll be here doing pleas for a while, so happy to do that. And if y'all run into difficulties next week, I'm easy to find, but I'm sure it'll all work out.
Thank you very
the trailer and the jeans. So, anything else then? All right. I thank all counsel for conducting a very professional trial. I know it was difficult for everyone involved, and I thank you all for your professionalism.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Hey, Sheriff, do y'all get the evidence